and welcome to the Wealth Approach podcast. I'm JR Gondeck. I'm joined this month by our friendly estate planning attorney, Wayne Cooper. And this month, we want to go into a topic I think many people, many families like to avoid and put off, or once you have that, not worry about updating. And it's Estate Planning Awareness Month. So we really want to touch on a couple of key items to be aware of and some talking points as to what you should consider, what you should look for as you look ahead to the key year next year with a lot of changes ahead. So with that, Wayne, let's maybe start on one of the big changes that's coming next year at the end, which is the sunset with the expiration of the tax cuts from a number of years ago, the federal exemption going down.
Yes, most estate planners right now are focused on the pending reduction in the estate tax exemption. Currently, as you'll see, 13.61 million per individual. So a married couple can use up to $27.22 million in wealth before they're subject to federal estate taxes. In January 1st, 2026, that amount gets cut in half. Originally, it was $5 million indexed for inflation. It was doubled to $10 million indexed for inflation. So with the indexing, we anticipate that that $5 million would have grown to $7 million by 2026, and a married couple would have $14 million together. The problem wealthy taxpayers are facing is that if they don't use the exemption before it's reduced, they lose it. And in order to get the benefit of the higher exemption, you have to make a gift or a transfer of an amount greater than the $7 million ultimate exemption. So, for example, if you made a gift of $3 million, when the exemption went down to $7 million, you'd only have $4 million of exemption left. So you would have lost the benefit of the full additional seven that you would have had the year before. If instead you made a gift of $10 million, when the exemption went down, you would not have -3 exemption, but you'd have 0 exemption left. So you would have gotten an advantage of $3 million of that exemption. So to the extent wealthy taxpayers are comfortable transferring a large amount of wealth, using up the total $13.61 million before January 1st of 2026 seems to be a good planning idea, but it's fraught with some dangers. So we do recommend talking to your estate planning lawyer or your financial advisor before making a gift of that size.
Wayne, what other changes are coming at the end of next year as far as taxes or other maybe key items people should be aware of?
So a lot of people are just focused on this exemption reduction, but a lot of the changes made in 2010 are going to expire, including the reduction in the top income tax rate. So currently 37%, going back up to 39.6%. Some of the deductions that are no longer allowed are coming back into the law. However, with that, there are lower exemption amounts, like the standard deduction and the like. So income taxes are also going to be an issue beginning in January of 2026.
So kind of putting all that together, everyone focusing on your estate, there's a broader tax planning conversation to be had as well, making sure this all fits together. And next year is just a key planning year to make sure you're ahead of this and proactive looking into 2026. So with that, Wayne, maybe, some of the things that come to mind, as we look through our families and changes over the last, maybe really since the pandemic, some common themes and some common things to be aware of. I think number one, if you look at change of residence, since the pandemic, many people, even younger generations have moved to other states. People that have retired have moved to other states, changed residences. Maybe if we just focus on, two states, Illinois and Florida, which is where we have offices, maybe some talking points around that change of residence, Wayne, when you think about Illinois versus Florida to be aware of.
Sure. Well, a lot of movement around the United States since the pandemic. And one thing people should know is that if their estate plan was valid in the state of residence when it was executed, it will be recognized in the state they moved to. However, the rules regarding the estate taxes in that state could be different. So you should always review your estate plan to see if it conforms with the rules that are applicable in that state. One of the pitfalls we see that people are getting tripped up with in their move from Illinois to Florida is that they think if they no longer live in Illinois, they won't be subject to Illinois tax. But that's only true if they don't own property in Illinois. So quite often clients are maintaining or retaining their residence or a home in Illinois. They move to Florida and they think because that home is worth less than $4 million, they won't be subject to Illinois estate tax. However, that is not how the Illinois estate tax works. If you have property in Illinois and you have a total of state of over $4 million, you are going to be subject to Illinois tax on a proportionate amount of your assets. So they don't just look at, say, $1 million home being less than the $4 million exemption. If you had a total estate, excuse me, of $5 million and $1 million home in Illinois, you would pay the tax on, you'd compute the tax on $5 million. The Illinois property was 20% of the total assets, so you would pay 20% of that tax in Illinois. So knowing how ownership of residences and other property in other states is important in your overall estate plan.
And now maybe touching on fiduciaries, Wayne, maybe the key fiduciaries to be aware of when you set up your plan or you're building your plan. These are important people. And as you either change, maybe some of that needs to be updated or life events happen or changes. Maybe you want to walk through, some of the key things to think about with reviewing fiduciaries.
Sure. So when we talk about fiduciaries, we're basically talking about guardians for minor children. We're talking about the executor of your estate, trustees for your trust, and the agent under your powers of attorney for property and health care. So guardians, you should always review. People change their guardians all the time as their children get older and also as their guardians get older. So quite often people may name their parents as guardians for their young children, but as the parents get older, they really may not be equipped physically to raise young children or worse, teenagers. So that should always be considered as to who's best to raise your children if something should happen to you at that moment. Because you never know when that event could occur, even though it's unlikely, we like to plan for that. The executor is more of an administrative task. Again, if you move, the executor may be at a different state. You might want to pick somebody in the state you're residing in. That's important. So the court would have jurisdiction and you wouldn't need to, the executor wouldn't need to give a bond in order to represent the estate. So the executor is more of an administrative task, basically gathers the assets, transfers them to the trust, and prepares final tax returns in the estate tax return. So you usually want someone who has some business moxie in order to fulfill that position. The trustee is the one who manages the assets ultimately and uses discretion as to how to distribute those assets for the benefit of the beneficiaries according to the terms of the trust. So you always want to make sure that you and your fiduciary, your trustee, are on the same wavelength as it comes to what they think is important for the use of wealth and raising children and access to money. Powers of attorney for healthcare, property. Property usually follows the trustees, but healthcare is a little different. You want somebody who will be able to make healthcare decisions for you that are consistent with your views rather than their own views. So if you do not want to have life maintained artificially, you want to make sure your agent is someone who is able to make that tough decision of turning off the machines and allowing you to die peacefully. But those are things you should always review because people change, we grow older, facts change, and those are the people you're trusting to handle your loved ones and your wealth going forward.
The third one, Wayne, obviously the both real estate, stock market, asset prices have gone up quite a bit really since the pandemic. I mean, markets, as we sit here with this recording, are more or less at all-time highs in many cases. And as you contemplate updating your estate, your asset picture in many cases is a lot more than it was even a few years ago. And there's a lot of implications to that change of value in updating and staying current with a lot of that.
So having a good handle on your net worth is important for so many different reasons, especially in estate planning. And people are often surprised how much wealth they actually have that's included in their taxable estate. So when doing a net worth statement, not only do you have to include your investment accounts, your real property, you also have to include any retirement savings you have, life insurance. Quite often, those aren't considered as your personal assets, but when you add them to your estate, you could find that you might be creeping much closer to the taxable estate or actually going substantially over the amount, which might require some current planning. One of the things we recommend is with technology the way it is, it's very easy to allow your financial advisor to have access, at least viewing access to all of your accounts in one place. And what that allows the advisor to do is easily update your net worth statement so you always know where you are from a taxable point of view. And also, one of the things the Learner Group does is preparing flow charts of the estate. So updating the net worth statement will flow into the flow chart and it will show who will receive wealth upon each death, what type of bucket it's held in, whether it's a retirement asset, a trust, if it's outright, if the trust is subject to GST tax, which is generation skipping tax or not. But it gives a good view of the flow of assets upon your death and is important to keep up to date on a regular basis.
Well, and as my mentor and founder, Gene Lerner, used to say, there's only three things you can do with money, Wayne. You could spend it, you can give it away, or give it to the government, right? And that flow chart is so important to identify kind of that flow. How much might be going to taxes, right? And a lot of families would rather that go to their family and not directly to taxes. So having that updated net worth statement, as you said, is so important to help you see the picture, Wayne, so we can help guide families if there's way to mitigate some of that through planning. And then ultimately, how much goes to your heirs, right? And seeing how much is in each bucket, each generation is very helpful to just look at an annual basis to make sure you still want those amounts to go to those people, right? And it's very important to stay organized, as you said, Wayne, because it can make the process ongoing that much simpler and easier to maintain and update as the years go on. So now looking at the fourth life events, right? And you don't have to look any further than myself with a baby, 2 days away, thinking about what you'd want to update, a new trust, college planning, updating your documents, all those kinds of things. So maybe, Wayne, let's touch on a few life events that are key and maybe some reasons why we should stay on top of those.
Sure. So, having more children is a life event that might require the review of an estate plan. Most estate plans will anticipate the birth of additional children for younger people. However, anytime one is added, you may want to review that to make sure that that all children would be included, not just the ones that were born and living at the time the will was created. You might also want to check for marriage and divorce. So marriage, very important because spouses have statutory rights to share in estates. So if you don't update your estate plan, you might unintentionally be transferring assets to your new spouse outright rather than in trust, or children might wind up inheriting outright rather than in trust because of a marriage. Divorce, again, your spouse is probably named in your estate plan. And if you are divorced, many states, not all, but many states will treat a divorce for estate tax plan purposes as if the ex-spouse had predeceased you. A lot of times that will only count or be considered for inheritance purposes, but doesn't necessarily apply for trustee, executor, guardian, things like that. So you always want to check to see how these life events could affect your estate plan. One of the things that a lot of people miss is we always advise clients when they're doing estate planning, not only looking at their own estate and how it would flow to their children, but also looking up to their parents and maybe even their grandparents' estates to see how those assets that they might ultimately receive might affect their tax situation. Quite often, if the child's generation is the wealth creator, the inheritance of modest wealth from the parents might not be a tax problem for the parents, but just adds to the tax problem of the wealth creator child. So planning for the parents and or to inherit from parents is very important in the process to save taxes down the road.
And Wayne, I think that's a key thing we've worked on over the years, our family meetings, right? Because I think completing the entire process, it's difficult and a lot of work and a lot of thought goes into building your own estate plan. And there's a lot of time focused on what me and my spouse or might want and plays out. But a lot of times, what we see is people don't communicate back either up a generation or down a generation to kind of complete the entire family loop as far as communication. And it's invaluable, as you said, Wayne, because a lot of times we find, talking about a new child being born, well, parents or grandparents might want to fund something, but so do the parents of the child. And if there's not good communication, a lot of times what we find is it's either overfunded or it's not consistently funded, is a common challenge we see overall. And it's as you're building toward paying for college, which we did a recording a few months ago, if you recall, the estimate for 4 years of private tuition, 18 years, will be $1 million. So it's very expensive. So again, I think closing the loop on family meetings. And again, you don't have to go into all the details of how much money is there. It's really consistent with the structure of how things flow, what trusts are created, and how they fit together is critically important. As you evolve as a family, you can get comfortable to sharing balances and values and those kinds of things. But I think that's a key thing that families can continue to consider, especially next year as you update things, making sure that you do communicate either to your parents, grandparents, or back down to your kids or grandkids, in the long run, because it's just invaluable as we've seen over the years.
Yeah, we find sometimes it's very awkward or uncomfortable to talk to your parents about estate planning. Sometimes they don't want to disclose it. They might think you're being too anxious to inherit, rather than just making sure things are in good order. I always suggest that you can raise the issue with parents when you get your estate plan in place. It's an easy conversation starter to say, Mom or Dad, I just got my estate plan in place, and my advisors asked if my parents' estate was in order. So maybe it's a good time for you to sit down with an advisor and make sure your plan is in order and it's consistent with what me and my siblings, your other children, are doing to make sure it all fits together.
Maybe one last quick, thought for families. How often, Wayne, should you be looking at things, once the plan is in place, and maybe what's a good thing to do annually?
So I recommend that every client sit down with their financial advisor at least once a year to at least review where they are from an estate planning point of view and see what changes or action might be required. October 15th just passed, which is the extended due date for individual returns. So people are taking a deep breath thinking, okay, I don't have to worry about taxes to April. But I always think that after October 15th to the end of the year is always a good time to review estate planning, because for one, you've got your annual exclusion gifts. Those are use them or lose them. So you want to review whether you want to make annual exclusion gifts, whether you want to.
And how much are those currently this year, Wayne?
Currently, they're $18,000 per year per person. And by person, I mean donee, the recipient. So a individual could make gifts to 100 different individuals of $18,000 without incurring any type of estate tax, gift tax, or any type of transfer tax reporting. So, but as of January 1st, you would lose the 2024 exclusions. So it's always good to see whether that makes sense or not at that time.
And then we talked about staying in order as far as your net worth and up to date as far as all your balances, because I agree. I mean, I think that's a key thing that families and everyone should be aware of. You have your financial accounts, but a lot of times you forget about your real estate, your private investments, your insurance, other assets that might be out there. So I think having a good handle on that, it's a lot of work typically up front, but then the ongoing maintenance, tends to be a lot less. But again, as you're sitting down this time of year, as you recommend, Wayne, updating that financial net worth statement and then looking back to the flow chart, and then does it make sense to do the gifting? Do I have everything in order? Do I have any other concerns? A lot of that time, once you put the work up front, is a lot less ongoing year to year.
Right. And it will be very helpful to your heirs, your family. If something should happen to you, they'll have all the information in one place. They won't have to be scurrying around trying to figure out, Is there insurance? Is there real estate? Where are the assets invested? How do I gather everything that I need to in order to uh, probate the estate if necessary, or even file final tax returns and the estate tax return? So having that in order is quite a benefit for your family if something should happen to you.
And I agree, Wayne. We still have some families where we're 10 years past the point of the parents passing away, and there still is, assets and things to be done because of the organization not being done up front. So I don't think we can emphasize enough how important it is to be organized, up to date, because again, leaving that burden onto your kids or grandkids, ultimately, they're busy with their families, they're growing, and it just adds a lot of legal expense and challenge to the next generation as you navigate and not have things in order. On top of it, the taxes and legal fees that are avoidable in many cases, are an additional challenge.
Yeah,
So,
there's so much available technology now to help with this process. The problem is people in my generation did not grow up with all this technology, so aren't as comfortable as using it. So it's a good idea for the younger generation, people in JR's generation, to actually help their parents possibly get the technology in place and ready so they can take advantage of having all this information in order and readily available when necessary.
so with that, we want to thank you tuning in. And again, I don't think we can emphasize enough how important next year is for many families to be aware and ahead of a lot of the changes that are coming in 2026. And again, that the more work we put in with you over the next 6 months, we'll avoid a lot of challenge and potentially a lot of financial challenge, in the years ahead. So with that, I want to thank you for tuning in, and we'll touch base next month.